Greetings to all of you at the Oklahoma Indian Sovereignty Symposium. My thanks to Justice Cogger for the invitation to be with you today. I just wish I could be there in person, but I've got to stay in Washington and know that I am there in spirit. In thinking about Indian sovereignty, I am reminded of the countless contributions that Native Americans have made to our nation and to the whole world. This great land had been cherished and cultivated by countless generations of Native Americans when the first European explorers set foot in North America. As Americans, we have learned so much from American Indians and Alaska Natives. Just in the time I have been Attorney General, I have learned so much in terms of sentencing processes that I am starting to apply in community justice context. From corn, cocoa, and quinine to art, architecture, and urban planning, Native Americans have made important contributions to our society. Native Americans are the first environmentalists. They understand that air and water and plants and animals must be respected so that they are with us for generations to come. And Native Americans have defended this nation from the Revolution to the present, and some are joined the ranks of heroes. So we have much to be thankful for in terms of the culture and the tradition of Native Americans. For American Indians and Alaska Natives, tribal self-government is the right of Indian peoples to live according to tribal laws on their own lands. In a changing world, Indian sovereignty enables Indian tribes to maintain the ongoing cycle of tribal culture as Native American communities embrace the challenges of the information age. The administration has repeatedly reaffirmed the Indian self-determination policy, including our strong support for tribal self-government and government-to-government relations between the United States and Indian nations. On May 14, 1998, the President issued an executive order on consultation and collaboration with Indian tribal governments, setting forth some of the fundamental principles of tribal self-governance. Since the formation of the Union, the United States has recognized Indian tribes as domestic, dependent nations under its protection. In treaties, our nation has guaranteed the right of Indian tribes to self-government. As domestic, dependent nations, Indian tribes exercise inherent sovereign powers over their members and territory. As a companion to the federalism executive order issued in regard to the states, the Tribal Self-Government Executive Order furthers the government-to-government relations policy by requiring each federal agency to develop an effective policy for consultation with tribal leaders and by directing agencies to be guided by respect for tribal self-government, sovereignty, treaty rights, and other Indian rights in formulating policies that significantly impact tribal governments. Consistent with the President's executive order, I am today reaffirming the Justice Department's support for tribal self-government and for treaty rights, our recognition of the federal trust responsibility, and our commitment to assist Indian nations in developing strong law enforcement systems, tribal courts, and traditional justice systems. Against this background, I would like to briefly touch on tribal law enforcement and tribal courts. Traditionally, the health of the Native American community was placed ahead of the individual's aspirations, and the life of the community was often viewed as part of an eternal circle. As Black Elk, the Lakota holy man, once said, "The power of nature moves in a circle. The sun comes forth and goes down again in a circle. The seasons form a great circle in their changing and coming back again to where they began." The circle is a symbol of harmony, the perfect symbol for Indian communities. Tragically, decades of poverty and dispossession have disrupted the harmony of many Indian communities. Violence in Indian country takes a heavy toll. While violent crime has fallen nationwide, violent crime rates in many Indian communities are rising. For example, the Navajo Nation is the largest land-based Indian nation with 17 million acres, and it has a homicide rate that, per capita, is comparable to our more violent cities. Yet, the Navajo Nation has less than one police officer per 1,000 residents, while similar non-Indian communities have 2.3 officers per 1,000 residents. Serious crimes in Indian country are predominantly violent crimes, including gang-related violence, juvenile crime, domestic violence, and child abuse. According to BIA reports, most violent crime is alcohol or drug-related. Last August, President Clinton asked Secretary Babbitt and me to work with tribal leaders to address the problem of rising crime in Indian communities. After consulting with tribal leaders, we developed a plan to fight violent crime in Indian communities by strengthening tribal police and tribal courts, improving investigative services, building detention facilities, fighting substance abuse, and funding prevention programs for children at risk. The first step is to get the resources necessary to fight this crime out to Indian communities across the nation. To do that, the Justice Department has requested $54 million for uniformed tribal police, $52 million for tribal detention facilities, $20 million for children at risk, $10 million to fight substance abuse, and $10 million for tribal courts. I should emphasize that these are our budget requests, and the first order of business in our efforts to reduce Indian country crime is to secure congressional appropriations of these funds. If appropriated, these resources would be used to build criminal justice systems needed to enable Indian tribes to fight crime effectively. Under the Indian Self-Determination Policy, as we work with tribes through these grant programs, we will work to ensure that our programs are flexible, sufficiently flexible to accommodate tribal traditions and to meet circumstances unique to Indian country. In our fiscal year 1999 budget request, we also seek more FBI and U.S. Attorney funding to improve the federal response to serious violent crime in Indian communities. To complement our efforts, the Department of the Interior is also seeking $25 million to enhance BIA criminal investigators, uniformed police, and law enforcement services. Of course, to fight crime in Indian community, our efforts in fiscal year 1999 must be continued in ongoing anti-crime programs. Reducing violent crime is a critical step for Indian country and important in ensuring a safe, stable community life based on true self-determination for all Indian nations. To make these changes effective, we must all work together in the coming months and years. A great Indian leader once said, "Let us put our minds together and see what lives we can make for our children." Today, let us put our minds together to provide safe and healthy communities for our children and our families. Tribal courts are central institutions of tribal self-government because they give life to the tribal values and to traditions embodied in tribal law. Tribal courts are also crucial to maintaining the law and peace in Indian communities. As Judge Canby of the United States Court of Appeals for the Ninth Circuit testified before the Senate Committee on Indian Affairs in August of 1995, federal courts cannot handle Indian country caseloads alone. Tribal courts must adjudicate basic criminal cases and resolve reservation disputes. The Justice Department recognizes the importance of tribal courts to tribal self-government, and we have worked hard to promote cooperation between federal, tribal, and state courts by encouraging a dialogue between the court systems. The federal courts of appeal for the 8th, 9th, and 10th circuits have developed committees to address tribal court issues, and some state courts have similar tribal state court committees. I understand that Chief Judge Seymour of the 10th Circuit will be holding a federal tribal court consultation in conjunction with the Sovereignty Symposium, and I applaud her efforts. We are also working to make Justice Department funding available to tribal courts. For example, the Bureau of Justice Assistance has also awarded planning grants for intertribal appellate courts. As we work to build tribal justice systems in Indian country, perhaps the tribal leaders might consider whether opportunities exist for their tribes to work together on a statewide or regional basis to enhance the effectiveness of our limited resources. Intertribal appellate courts may be one such opportunity. The Drug Court Program is another Justice Department program available to tribal courts. In fiscal year 1998, the Drug Court Program will award more than $1 million to tribal governments to plan and implement tribal drug court programs. When tribes have a range of sanctions and crime suppression, prevention, and intervention programs available, tribal criminal justice systems can reduce the volume of serious offenders who must be dealt with in the federal system. Through the development of tribal drug courts, we may encourage substance abusers on their road to recovery and prevent them from engaging in serious domestic violence or other substance abuse-related crimes. The Blackfeet tribe has developed a drug court program that involves the community in the process, from the tribal council to social services to the tribal community college, and this program is giving its participants a chance to finish their education. Similarly, by supporting a Boys and Girls Club on the Northern Cheyenne Reservation with programs that reflect tribal traditions and tribal culture, we may provide Indian youth an opportunity to find a sense of belonging in their own tribal community instead of joining a gang. We are seeking to expand juvenile justice prevention programs through our request for funding for children at risk. We know that more needs to be done to support tribal courts as institutions of justice. So as I stated earlier, the Department is seeking $10 million in fiscal year 1999 to aid tribal courts, and I will urge Congress to provide this funding. Let's work together to strengthen tribal courts and traditional tribal justice systems so that they may handle their rapidly expanding dockets, ensure public health and safety, protect the political integrity of tribal governments, and provide due process to all who come before them. As tribal leaders, you have the ultimate responsibility for determining the best avenue for building tribal courts as strong, independent institutions of justice. And you must be the first to cherish and to support tribal courts so that tribal justice systems may realize their promise as the guardians of tribal justice and tribal values. In closing, I would remind all Americans that our nation is a great land, one of great diversity, one in which we cherish freedom and liberty for all of our people. For American Indians and Alaska Natives, liberty means tribal sovereignty and self-government. Freedom means that Indian peoples may continue to live according to their own traditions on their own lands. This is a great tradition. At the outset, I mentioned how much I'd learned from tribal leaders across this land about sentencing processes. I will not forget being told, in your system of adversary justice, you ascribe blame. It's either guilt or innocence. You don't really go to the cause of the problem. You don't bring peace. You don't heal. With our sentencing circles, said the leaders, with our approach, we try to find what caused the problem and bring healing to it. We have so much to learn from each other as we work together in mutual respect and regard for the great traditions reflected in tribal values and for so much of what we want to do in terms of ensuring justice for all. I hope you have a wonderful conference.